Okay, good morning,
Good morning.
and welcome to a session of oral arguments for the Fifth District Court of Appeal. We're here on the case of McGregor versus Daytona International Speedway, 21-3218. I'm Kerry Evander. I'll be the judge presiding over this morning's arguments. And I'm pleased to introduce the other members of the panel. We have Judge Scott Makar. This is his first oral argument as a member of the Fifth District Court of Appeal. He served for approximately 10 years on the first DCA, but due to recent legislation and revamping of the district courts, he's now a member of our court, and we're pleased to have him. Also pleased to have Judge James Edwards joining us today. These oral arguments are being live streamed. And if you have any electronic devices, please make sure they're in the silent mode so the oral arguments are not disturbed. Each side will have 20 minutes. Appellant's counsel, if you wish to let me know how much time you wish to reserve for rebuttal, I'll try to help you in that regard, but there is a clock on the screen there. So with that, is it Mr. Cummings?
Yes, Your Honor. Thank you. And I would like to reserve 5 minutes for rebuttal.
Okay. You may proceed.
Thank you. May it please the court, good morning. Again, my name is Sean Cummings. I represent the appellant Pamela McGregor. The only issue on appeal this morning is whether it was error for the trial court to deny Mrs. McGregor's special request for a jury instruction. And the Supreme Court has established a three-part test to determine when a special requested jury instruction should be given by the trial court. And it says it should be given when, first, the instruction is an accurate statement of the law. Second, the instruction is supported by the facts and circumstances of the case. And then third, it's necessary for the jury to resolve all of the issues in the case. And if those three prongs are satisfied, then the instruction should be given to the jury, and it is error for the trial court to not do so. And in this case, the parties have agreed that the second prong of that three-part test has been satisfied. So I'll spend my time this morning talking about the first and the third prongs of the test. The first prong, again, which is that the instruction must be an accurate statement of the law. Here, it was taken verbatim. It was a direct quote from the case of Glav versus Caudill. It's a second DCA case. We didn't add any additional explanation to the appellate court's language. We didn't remove any part of what the appellate court said. It was a direct full sentence quote from the appellate court. And in fact, the trial court agreed with us during the trial that the special instruction that was proposed by Mrs. McGregor is an accurate statement of the law. She said, and I quote, "I agree with the plaintiff that it's an accurate statement of the law." And that quote can be found in the record at page 114. It's also quoted in the initial brief at page 19. The court did go on to say, though, although the instruction was accurate, she said, and I quote, "I don't know that it's necessarily mandated for the jury to have it." And so the court ended up denying Mrs. McGregor's request. But we can glean from her comments that the court was really concerned with the third prong of the test, whether or not the instruction was necessary.
Counsel, if I can interrupt just for a second with a quick question on the statement of the law. As I understand, this is a 1970 case, a quote from it, and it's never been, that portion of the opinion has never been cited by any Florida court. And in my research, no court nationwide has ever used the language in an opinion that you're attempting to have a jury instruction be made into. So I'm struggling a little bit. It is a statement of what the second DCA said in 1970, but in terms of sort of establishing it as a correct statement of the law that must be applied in this particular kind of case, I'm struggling a bit because of the lack of any other citations to it. If you could help me on that.
Of course, Judge McCarr, thank you for the question. And so I think one of the ways to answer that question is to talk about what perhaps an inaccurate statement of the law. And I think some of that question is answered by prongs 2 and 3 of the test, whether the law applies to the case and whether it's necessary. But just as it relates to the accuracy, what we do know is that Glav versus Caudill is still good law. It's been quoted even by this court, I think in June of 22. For the explanation of what gross negligence is in Florida and its contrast with simple negligence. And I've cited in the reply brief A couple courts who have actually quoted the factual explanation in GLAB that talks about when ordinary negligence does rise to the level of gross negligence under very special circumstances. So even though the language hasn't been directly quoted in other courts for the purpose of a jury instruction, it has been cited with approval, the proposition of law that's explained in GLAB. So that has been quoted with approval. And I'll mention the only real argument from the Speedway that the instruction was not accurate, both in the trial court and also in its brief, is that it comes from a case dealing with the issue of directed verdict versus a case dealing with jury instruction. And that's really it, that somehow an appellate decision dealing with directed verdict cannot or should not be used for the purpose of a special jury instruction. I'll point out the Speedway doesn't cite any authority of law for that proposition, that you can't use other types of cases to support jury instructions. But even outside the lack of support, the problem with the argument is that the principle of law that was at issue doesn't change between directed verdict and trial. It's the same law. And whether it applies to the case prongs 2 and 3, which I'll talk about in a second, but just as prong number 1, whether it's an accurate statement of the law, as long as the language that's being used doesn't alter or amend the law, the appellate court's language, then it is an accurate statement of the law and it meets the first prong of the test. And the trial court agreed with that assertion. Now, I do want to contrast, I think, what might be an inaccurate statement of the law, because I think it does help in this context. The actual instruction that was requested by Mrs. McGregor said essentially that ordinary imprudence under very special circumstances that were present in this case may be evidence of gross negligence. The key there being it may be evidence of gross negligence. It's still a jury determination. It would have been inaccurate, I think, had the request said ordinary imprudence under those special circumstances is gross negligence instead of may be gross negligence, because that actually alters the legal principle that was articulated by the second DCA. That would be inaccurate. That would not meet the first prong of the test, but it's not what we have here. Here we have a direct quote from GLAB. It's an accurate statement of the law. Therefore, it meets the first prong of the test. And again, the trial court agreed with that assertion. So with that, having the first prong being satisfied, I'll move to prongs number 2 and 3, which is again.
Let me ask you this. The jury was instructed that, given the standard instruction, if you will, the gross negligence means that defendant's conduct was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct. Would you agree that that is an accurate statement of the law?
Absolutely, Judge. It is.
And that is the bottom line. That was the question the jury had to decide.
It is, Judge, but one of the things the Aubin court says that I think is important here, and I talk about it when I get to the necessity part, but I'll mention it here as well, is that even technically accurate instructions are misleading if they're incomplete. And so even if the standard instructions technically accurately describe gross negligence, if the jury isn't also informed that there's another proposition of law or another legal principle that they need to consider when answering that question about gross negligence, then the instructions are incomplete and therefore they're misleading according to the Aubin versus Union Carbide decision. And I will talk about that some more when I get to necessity.
Okay.
So moving to prong 2 real quick, I won't spend much time. The Speedway has conceded that the facts do support giving the instruction. That is important when I get to necessity. And that the circumstances, that the reason that the instruction was necessary is because the circumstances that were present at the time that Mrs. McGregor was injured were such that they were inherently dangerous, and that because they were inherently dangerous, it required all the parties involved to exercise a greater degree of caution than what's ordinarily required. That concession by the Speedway is found at page 41 of the answer brief. So I won't talk more about prong number 2, other than we've agreed on it. But I will talk about that as as it relates to necessity, that the circumstances were inherently dangerous and that everyone agreed the parties needed to exercise greater caution than ordinary caution. And that becomes important when we talk about what the jury had to consider. So the third prong of the test, is it necessary for the jury to resolve all the issues in the case? And the key here is what makes a jury instruction, quote, necessary? And that question was answered by the Supreme Court. They said this: a special jury instruction is necessary if the jury might reasonably have been misled or confused by the absence of the proposed instruction. And this is the quote I was talking about before, even when the instructions are technically accurate, which is what the Speedway argues, and going to your point, Judge Evander, they are still misleading if they do not fully inform the jury on the law to be applied. So if the instructions given to the jury do not include all the legal principles to be considered by the jury, then the instructions are misleading as a matter of law, and the decision not to give an additional instruction to explain the outstanding legal principle is an abuse of discretion by the trial court, and it requires reversal. And in this case, we know that the jury instructions did not include all the legal principles because they didn't say anything at all about the
I'm going
explanation.
to ask you this. Do you believe that imprudence in response to circumstances requiring a greater abundance of caution is the same thing as conduct that's so reckless or wanting to care that it constitutes a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct? Or does that come off as setting forth a lower standard than the standard jury instruction?
I think it's different, Judge, and I think that goes to, in the Speedway's closing arguments, one of the things they say, and I quote it in the brief, is that if you find that Amy, who was the person in the tower controlling the movement of the tow truck when all this happened, if you find that she was negligent, then your job is done, because the answer to question number one is no, you're done, you go home. The problem is the explanation in Glab says very different, that when everyone agrees, as they did in this case, that greater caution is necessary, then if you find that Amy was negligent, you have to ask, I think you have to go one more step, which is you've already established that she has displayed ordinary imprudence because you found that she's negligent. The question is, does that ordinary imprudence now rise to the level of gross negligence because of the extra degree of caution that she should have been showing? So the arguments by the Speedway that if you find
Counselor, you're now arguing exactly what you said would be an inaccurate statement of the law, that if she were negligent, merely negligent under these circumstances, that would constitute gross negligence. And that's a problem I have. I understand how you can make an argument of that, but you're saying that now, under these circumstances, if she were merely negligent because it was an inherently dangerous event, she would be guilty of gross negligence. And I don't find that to be an accurate statement of the law. And that's almost what you would have to argue. And if you were given that instruction, that would be an improper instruction. Would you agree?
I would agree that that would be an improper instruction. If that's the way I said that, I didn't say it clearly. I think what the jury had to do is that if they found Amy was simply negligent, ordinary negligence, ordinary imprudence, then they had another step. They then had to look at whether that imprudence or negligence rose to the level of gross negligence because of the additional care that was required. So again, I'm not saying that they would say she is gross negligent. They would have to make that determination considering the fact that she displayed conduct which was ordinarily imprudent, plus that she owed a higher degree of caution than is ordinarily required. So that's the step the jury didn't know about. And I think going back to what the Auburn court said, if there is any principle of law omitted from the jury instructions, then the jury instructions are misleading. And the reason that's important is because part of the standard instructions tell the jury, I, the court, am going to give you all of the law to apply in the case. And you cannot consider any law that I have not given you. And that becomes very important because the Speedway's response at trial and what the court ended up doing was saying, we're going to allow counsel for Mrs. McGregor to argue the proposition of law in GLAB to the jury, which is what was done. So in fact, we were encouraged to do that. The Speedway said, and I'm quoting, "We fully expect them to argue this to the jury. It's just different in a jury instruction." So we were allowed and permitted to argue the principle of law in GLAB to the jury. And by the way, before I get to the problem with that, I want to point out the fact that both the court and the Speedway said that we can argue this to the jury is a concession that the principle of law is accurate and it is applicable to the case. Because certainly the Speedway wouldn't say, we're going to allow you to argue an inaccurate principle of law to the jury during closing arguments. So
Counsel, if I could ask a quick question. I couldn't find the word imprudence in the closing arguments. So did you actually use the phrase or use the language in the argument or not?
So the actual word imprudence, no, Judge McCart. And one of our concerns was that if, even given permission to argue it, we couldn't, for example, put up our requested jury instruction and say that to the jury because it wasn't part of the actual jury instructions. So we were given latitude to argue the principle without telling the jury that this is, the law and the jury instructions that you need to apply. So it was a very tight rope that we had to sort of walk in explaining the principle without saying that these are instructions to the jury because they weren't. And that's part of the problem with doing what we were asked to do. And by the way, the courts in Florida have addressed this very point. And so I quote the case of Reynolds versus Jewett on this point. That court has said this: leaving it to the parties' attorneys to explain to the jury in closing argument what legal principles apply is an inadequate substitute for an accurate, relevant, and complementary instruction that contains legal principles not covered in the instruction. So the Florida courts have been very clear in this point. If there is a legal principle that applies and the jury should hear about it, it must be contained in the jury instructions. It cannot come from counsel. And the reason, twofold. One, you create a big disconnect to the jury. It creates confusion. They're hearing from the court on one hand, here's the law. They're hearing from counsel for one of the parties, here's the law. And it sounds a little bit different because it's not coming from the bench. And then the jury has to consider the last part of the jury instructions, which says you are only to consider the law provided by the court. And so the jury immediately is going to disregard any legal proposition argued by counsel that didn't come from the court. And that's why the courts in Florida, including the Jewett court, have said that's not permitted. If there's a legal principle.
You're about a minute and a half into your rebuttal argument, just so you know.
Thank you, Your Honor. And so that's why the Florida courts have said, if there's a legal principle, it must be in the jury instructions. If it's not, it's misleading. It's also confusing to let counsel for one of the parties argue it. And therefore, that is an indication that the jury instruction was necessary for the jury to resolve all the issues in the case. So we're asking this court to find the trial court did abuse its discretion in denying the requested instruction while still permitting counsel to argue the principle of law to the jury. So we're asking this court to reverse that decision and remand the case for a new trial. Thank you. And I'll reserve the rest for rebuttal.
All right. Thank you. You have about 2:42 left for rebuttal. Mr. Cole, you may proceed with your argument.
Thank you. Good morning, Judge. Good morning, members of the panel, and good morning, Mr. Cummings. The trial judge did not abuse her discretion in denying to give this special jury instruction requested by the appellant. If the special instruction was given, it would eviscerate the protections given to motorsports facilities under section 549.09 of the Florida statutes. As this court is aware, we lost the prior summary judgment ruling because the court quoted heavily from 549.09 and said it did not extend to gross negligence, but it did extend to negligence. 549.09 allows motorsports facilities like the Speedway to ask non-spectators entering its facility to sign and release and waiver of liability. to protect them from lawsuits of negligence. Mrs. McGregor did sign this release and waiver of liability. So she essentially released the Speedway for any acts of negligence whatsoever. This is why they had to sue us for gross negligence. And if the jury was instructed that negligence in situations requiring a greater abundance of caution may equate to gross negligence, the protections of the statute would be rendered meaningless. We would have no protection under the statute. So it makes no sense. So I disagree with my esteemed counsel, Mr. Cummings, that this is an accurate statement of the law. It's not an accurate statement of the law in a motorsports case where a non-spectator has fully released the Speedway for negligence. And that's exactly what occurred here. Because again, they released us for negligence. She's a non-spectator, she's a worker. If they were allowed to come in and say, in times where a greater abundance of caution is required, negligence may mean gross negligence, the release would be meaningless, the protections of the statute would be meaningless, and we would therefore have no protection. The court would be rewriting what the legislature put in that statute. Because every race, as we admitted, as they admitted, requires a greater abundance of caution. This is a dangerous sport. You have race cars going around a track. You have motorcycles going around a track. You have trucks going around a track. So since every case requires a greater abundance of caution, and this is why we didn't argue prong 2 of the 3-prong test, since every race requires a greater abundance of caution, if they were allowed to argue mere negligence may mean gross negligence, we have no protection under the statute. We have no protection under the release. And this court has already found, and Mr. Cummings, I don't believe will object to this point or disagree at this point, that she can't sue us for negligence. So this is just a backdoor way of getting negligence back in the lawsuit where it didn't belong. It didn't belong under the pleadings. It didn't belong under the statute, and it doesn't belong under the law. So GLAB, for those reasons, is a complete inaccurate statement of the law.
Counsel, I
Now-
have a question for you.
Yes.
In your brief, you argue that there was ample evidence that plaintiff herself was the sole cause of the accident and injury, or that Ms. Davila was, or that the tow truck driver was. My question for you is the comparative fault of any or all of them, does that negate gross negligence on the part of the Speedway?
No, Judge Edgeworth, it's not, but I was pointing out those facts, and I went heavily into the facts, and Mr. Cummings didn't, and there was a great contrast in the two briefs, but I went heavily into the facts because the Supreme Court has said that unless the verdict results in a miscarriage of justice or the jury has been misled, then the special instruction does not require reversal here. So I wanted to show that this verdict was not a miscarriage of justice. The jury could have easily have found that this accident was wholly the fault of Mrs. McGregor. This jury could have easily.
You think you really want to argue that point to us, that it was
No, I'm
all her fault?
No, I'm just saying the jury, no, I'm not saying that. What I'm saying is the jury could have seen that, hey, Mrs. McGregor was not grossly negligent, and the failure to give this jury instruction did not result in a miscarriage of justice because there were other reasons that could have occurred that could have caused this accident. But I agree with you, Judge Edwards, the focus would normally be Ms. Davila's gross negligence. But for them to be able to backdoor in mere negligence may mean gross negligence in situations requiring a greater abundance of caution eviscerates the statute and eviscerates the release she signed, rendering them meaningless because every race requires a greater abundance of caution. Everybody admitted to that. So we have no protection under the statute. We have no protection under the release. And I would agree with you, Judge Makar, when you were asking Mr. Cummings these questions. This statement in GLAB was very narrow. The court said numerous times, we are simply reviewing whether it was appropriate to enter a directed verdict and a guest passenger statute. That's what GLAB was. GLAB then went into a lengthy discussion about the evolution of gross negligence in the state of Florida. It cited the cases like Caraway versus Ravel and other cases. And it stated the quote, which Mr. Cummings has hung his hat on, not to be disrespectful, but hung his hat on both below and on appeal and asking for a reversal here. But no case has ever said that that dicta requires a court to then ignore the gross negligence jury instruction, which was approved by the Supreme Court 40 years after GLAB, or ignore the definition of negligence, which is contained in the statute, which was implemented and passed by the legislature 20 years after GLAB, and require a trial court to give that special jury instruction in a motorsports speedway case. And that's what we have here. So GLAB is, as the trial court found, and we conceded, is still good law to the extent that it's never been overturned. But it's not good law to the extent that it requires a special jury instruction over and above the gross negligence jury instruction in a motorsports facility case where we obtained a release, as we are entitled to do under 54909. So I would disagree with Mr. Cummings that it's not good law for this narrow purpose. It may be good law on the definition of gross negligence and how the court went through dicta and it's never been overturned, but it doesn't apply to this case. And no court has ever found that it does. As you said, Judge McCarr, that no court in Florida or anywhere outside of Florida has ever cited to GLAB. And both Mr. Cummings and our trial lawyers admitted to this for the proposition that it requires a special jury instruction that was from the dicta quoted in the case. So, and I would also argue that if this court does allow this special jury instruction to be read to the jury, it would also be changing the definition of negligence that the legislature put in the statute. The legislature specifically defined negligence in the statute, and it did not include the words of GLAB, which came out 21 years before the legislature wrote the statute. And it didn't include language that in a motorsports case, if a greater abundance of caution is required, negligence may mean gross negligence. It specifically defined negligence, and it said negligence doesn't include gross negligence. And again, this is why we lost the first appeal, and this is why the court reversed the summary judgment. The court said that Mrs. McGregor was the prior court, and I know your honors are not on that court, but the prior decision of this court was that she was entitled to her day in court, and she got her day in court. I would also argue again that the standard jury instruction, as Judge Evander pointed out, didn't mislead the jury. This was a very simple, straightforward case. Was the dispatcher grossly negligent in what she did at that day and time in that probably 30-second or a minute window of time? And that's what the jury had to decide. This was a 4-day trial on liability only. I think there were 10 or 12 witnesses called. The jury heard from the dispatcher, Amy Davila. The jury heard from Mrs. McGregor. Admittedly, she couldn't remember the accident, but it heard from her husband, who was a witness to the accident. It heard from 2 Speedway personnel who were on the other side of the cement wall who witnessed the accident. It heard from the SCCA, Sports Car Club of America officials. It heard from Daytona International Speedway and International Speedway Corporation officials. And it took 4 hours to deliberate in order to find its verdict. The jury didn't ask any questions about the definition of gross negligence. It didn't ask the court to read back the law or anything else. In fact, the only thing the jury asked was to have Mrs. Davila's supervisor's testimony reread. So there's no evidence that the standard jury instructions misled the jury. And these are standard jury instructions, again, that were implemented by the court after many years of the Supreme Court, after many years of fine tuning and argument and publication to the members of the bar, 30 years after GLAB, 40 years after GLAB. So clearly they didn't consider the dicta in GLAB to be important in the definition of gross negligence. It's a very simple issue. Was she grossly negligent? After many days of trial, many hours of deliberation, the jury found that she was not. And again, and Judge Edwards, and I agree with you, the focus should be on whether Mrs. Davila was grossly negligent or not. But I just wanted to point out, and I did it probably in too much length in my brief, that there are other factors going on here. So this was not a miscarriage of justice. It was a very unfortunate accident that Mrs. McGregor suffered. It was a very tragic accident that she suffered, but there was no gross negligence on the part of the Speedway. We originally got a summary judgment in the case. The court then reversed it for a trial. She had her day in court. She had a complete opportunity to present her case, and she did. And the jury made its decision. So
Mr. Cole, doesn't the standard instruction on gross negligence preserve the protection that the Speedway is entitled to with its waiver or release? even if you gave the special instruction that Mr. Cummings is offering for us to consider?
No, Judge Edwards, I respectfully disagree. I don't believe it does, because it allows them, as I mentioned before, to backdoor in negligence. The jury was instructed, this is negligence, this is gross negligence. They have to show, Mrs. McGregor and Mr. Cummings had to show the Speedway was grossly negligent. If you're allowed to give this special jury instruction, which uses terms like imprudence and other terms that are not defined for the jury, and then say, since we all agree a motorsports race requires a greater abundance of caution, and it was right in the release she signed, so of course we all agree to that mere negligence could be gross negligence. It eviscerates the grossly negligence instruction and the protections of the statute. The statute is rendered meaningless. The release is rendered meaningless.
So if I could interject, what I hear you saying is that, if it was a tow truck on the interstate and was backing up and hit someone and injured them catastrophically, that could be negligence. And simply because this happened in the pit area at the Speedway doesn't necessarily transform that into an act of gross negligence, and maybe still may be negligence. Is that, that's what I'm sort of hearing you say?
I'm saying, in addition to all the other, yes, Judge McCarr, that's what I'm saying. What I'm saying is that this was a very narrow case. We had protections under the statute. The legislature has occupied this field to the extent that we're allowed to get a release. We did get that release. And to then allow them to backdoor negligence again makes the statute meaningless. They may be entitled to this special instruction if a tow truck was backing up on I-95, which was negligence, and the tow truck should have used greater abundance of caution, and an accident occurred. They may be entitled to that. That's not what we have here. And that's what the trial judge found. The trial judge went through many hours, probably about an hour of discussion on this issue. She read the memos, she read the cases, she talked about the Judge Orfinger and the failure to give a special instruction, and I believe it was a manslaughter case. She said, I'm not convinced it entitles you to a special instruction. In this case, she said this, she recognized this was a special situation because it was a motorsports case. And based on that and the facts of this case, she correctly denied and did not abuse her discretion in providing that special instruction. So with that, I really have nothing else to add. I'll rely on our briefs, I'll rely on the facts, and most importantly, I'll rely on the statute, which was quoted in our brief, and state again that the legislature occupied this field, said what we could and couldn't do, and they should not be allowed to render that statute meaningless with a special instruction that comes from dicta from a 52-year-old case, which has never been cited for special instruction anywhere in the country. And I'll ask that the court affirm. Thank you.
All right, thank you, Mr. Cole. Mr. Cummings, rebuttal. You have 2 minutes and 42 seconds left.
Thank you, Judge. In response to the argument that it eviscerates 549.09 to include the instruction, respectfully, I disagree with Mr. Cole. The only way this instruction becomes part of this case is if prong number 2 of the 3-part test is met, which is everybody at trial has to say that the facts and circumstances of the case support it. And this is not a situation where it's just a tow truck backing up. Those are ordinary circumstances. That happens all the time. We're talking about a racetrack, an active race, cars at 160 miles an hour, a disabled car loaded that the testimony was the tow truck driver couldn't see behind him because of it, and he relied on the person in the tower to be his eyes and ears. He was given an instruction to drive in reverse down pit road during an active race, and that was against the race rules. You're not supposed to move in a counter race direction. So it's all those circumstances combined that create a very unique special circumstances that says this circumstance requires everybody to display a much higher degree of caution. And by the way, the person in the tower testified she knew there were people around the area. She didn't see Mrs. McGregor specifically, but she knew there were people in the area. Those facts combine to create a situation where you've got to be on your tiptoes. You have to display the very highest degree of caution. If you don't do that, that can be evidence of gross negligence, and that's what the jury has to decide. So it does.
Now, Mr. Cummings, in terms of the necessity, in order to prevail, you had to prove what's in the standard instruction for gross negligence, correct?
I'm not following. No, Judge, I don't think so.
Well, by the question on the verdict form, you basically had to prove that there was the reckless or wanting in care that amounted to a conscious disregard or indifference. I mean, without it, if you weren't able to prove that, then even if you had the GLAB instruction, you shouldn't have been entitled to win, should you?
I think it's a fair question, Judge, and I agree that the jury still has to consider the standard language of gross negligence. The disconnect is that the GLAB, and what the GLAB court explains, is that even ordinary imprudence can demonstrate a conscious, reckless disregard of people's life and safety when the people who are making that conduct are required to exercise greater care. So yes, I think that standard language is still important, but there's an extra step the jury didn't know about because they weren't provided the legal principle in the instructions, despite, again, us being allowed to talk about it during closing arguments. So again, I'm asking the court to reverse that decision.
All right, well, thank you both for your arguments, well-argued case, and we will be in recess.
Thank you.
Thank you very much. Thank you. Have a great day, everyone. Mr. Cummings, thank you.
Bye. Same to you.